Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 72 now. We're going to take a slightly different approach to the podcast this time around. I've got two cases to talk about, and I thought I'd also spend the last section of the podcast talking about the proposals by the new Conservative government for changes to employment law, and just a few sort of really personal thoughts on them. I would genuinely be very interested to hear what other people think, because it's clear there are going to be some changes, and it's also equally clear that some of these changes are going to be pretty controversial. Let's start with the cases. So NHS Direct and Gun. So this is an EAT decision looking at a Tupe transfer, and whether an employee who objects to his or her Tupe transfer is able then to claim discrimination against the transferee on the basis of being a transferring employee or a prospective transferring employee under Tupe is equivalent to being a job applicant. The background to this: in order to claim discrimination in a case involving the prospect of reasonable adjustments, the claimant has to fall within certain parameters laid down by Section 39 of the Equality Act. So an employer may be required to make reasonable adjustments to help disabled job applicants, employees or former employees. In this instance, the EAT had to consider whether a proposed transferee who offers employment ahead of a Tupe transfer is effectively doing so to a job applicant as defined, if it's an existing employee of an undertaking which is due to transfer across under Tupe. To turn it on its head, if you're a prospective transferee, are your prospective employees coming across job applicants? The EAT also considered whether the answer to that question would change if the employee of the transferee proposed to make changes to the terms and conditions of the employee's contract to employment once the transfer is effective. Let's put all this into context. The employee, Mrs. Gunn, suffers from rheumatoid arthritis and was qualified as disabled under the Equality Act. She worked for Shropshire Doctors Cooperative, Shropshire Doctors for these purposes, and she worked 8.5 hours a week for a part of a service that was then subsequently set to transfer under Tupe to NHS Direct. As part of that, it was also going to be relocated from Shrewsbury to Dudley. NHS Direct contemplated ceasing work at Shrewsbury, thereby creating a potential redundancy situation. NHS Direct wrote to her to offer her suitable alternative employment. But, and here's the kicker, prior to the transfer, NHS Direct also informed employees that it required all staff to work 15 hours a week minimum. Mrs. Gunn's proposal of increasing her hours from 8.5 to 10 was refused. Consequently, Mrs. Gunn objected to the transfer of employment, and of course, as we all know, that means that the Tupe transfer then terminates your employment rather than transferring it over. She brought a discrimination claim against NHS Direct, asserting that to insist, albeit in advance of her actual employment by NHS Direct, that her hours of work should change, was to threaten to cancel a reasonable adjustment that had been made to her hours in the light of her disability, and that doing so was a discriminatory act. Therefore, she never actually transferred from Shropshire Doctors to work for NHS Direct. NHS Direct applied for the claim to be struck out on the grounds that Mrs. Gunn had never been its employee, didn't fall within any of the classes of individuals qualified to bring a claim under the Equality Act. The employment judge refused to strike out the claim, broadly speaking, on the basis that Mrs. Gunn's request made her an applicant within Section 39. NHS Direct appealed to the EAT, arguing there could be no question of a transfer of a contract of employment under Tupe amounting to an offer of employment, because the transferee was obliged to accept the contract as it was. NHS contended that, outside Tupe, offers of employment involve an employer making a choice, first as to who the employee should be, and second, the terms of the offer. Where there is a Tupe transfer, NHS Direct argued that the transferee has no choice. It has to accept the employee, and it must honour the existing T's and C's of employment, such that it has no right, other than any which the transferor or employer might have, to alter the employee's terms, and as such, that could not make Mrs. Gunn an applicant. The Secretary of State for Education also got involved, arguing that the situation of employees subject to a Tupe transfer is not comparable to applicants applying for or being offered employment. The point was made that to require transferees to investigate any requests for such adjustments pre-transfer could be a huge task in the case of large transfers, and require transferees to make decisions without having full knowledge of the situation of many affected individuals. Such a requirement would remove the certainty afforded by Tupe transfers, namely that people transfer on existing terms and conditions. Mrs. Gunn argued that the offer of 15 hours a week was expressly referred to as an offer of suitable alternative employment, and that NHS Direct was an employer as per the definition under the Equality Act, and in giving notice of its required minimum hours of work, it was making arrangements for deciding who should be offered employment. Well, the AT agreed that Mrs. Gunn could not be regarded as an applicant for employment that she already enjoyed. Her contract would be automatically transferred to NHS Direct exactly as it was. Any alteration would not take effect until after the transfer. There was no room for any offer from NHS Direct being linked simply to the Tupe transfer. Mrs. Gunn would retain all of her Equality Act remedies against NHS Direct that she had against Shropshire doctors. The EAT therefore concluded that, so far as Mrs. Gunn's terms and conditions of employment were concerned, she was in exactly the same position pre-transfer as she would have been in had she been employed by NHS Direct post-transfer, just as vulnerable to the suggestion that she should work a minimum of 15 hours a week. What was to change, therefore, were not the terms and conditions to which she could be required to work, or the law relating to any changes made to those terms, but rather the willingness of those individuals to seek to change her terms. So far, so bad for Mrs. Gunn. However, the EAT then pointed out there was an email sent from NHS Direct to Mrs. Gunn which stated, quote, "We are happy to offer you a contract for 15 hours per week of suitable alternative employment at our Dudley site. I appreciate that you stated that your disability means that you do suffer with fatigue. Of course, we would look to support you by making reasonable adjustments whilst at work, and I'd be happy to discuss this further with you." Unquote. The AT considered that the use of the words, quote, "offer of suitable alternative employment," unquote, in the context of a proposal to discontinue work at the place where Mrs. Gunn had been located, suggested that NHS Direct was contemplating that post-transfer Mrs. Gunn's post was likely to be made redundant, and in accordance with usual employment practice, NHS Direct would seek to offer her alternative work at a different site, so that she didn't lose her job. The AT considered whether this quote-unquote offer of suitable alternative employment at a different location meant that she was a job applicant for the purpose of the equality legislation. The AT concluded that what was being offered here was a fresh contract of employment, and not employment which Mrs. Gunn had already secured by virtue of the Tupe transfer. The AT held that the NHS Direct showed at the time that it thought there was a genuine redundancy situation, and had therefore made Mrs. Gunn an offer of suitable alternative employment, resulting in her qualifying as an applicant for the purposes of the Equality Act. So in other words, it was the fact that they were also changing her location that was key. So look, in essence, what was going on here was the court identified a gap in the protection for employees in connection with Tupe. If the individual had been transferring into her current job on a Tupe transfer, but the transferee had said that they were going to change the hours of work in advance of the Tupe transfer date, then she would have been left potentially without a remedy. She would not have been a job applicant, and therefore, if she wanted to sue the transferee, the parameters, the ambit of the discrimination legislation would not have helped her. Note, however, that of course if she had transferred over and then the change had been imposed on her, there would have been no question but that she would have been covered potentially by the protection offered by the legislation. As it is, I suspect the court was quite pleased to be able to point out an alternative solution on the facts here. The court determined that there was an alternative offer of employment, and therefore she was in effect a job applicant. Clearly, one can see the justice in coming to this conclusion, but another claimant in another set of circumstances might find they lose out. Here, there was a change of location of work as well, and with the benefit of hindsight, and boy is that always a useful tool, the letter written to her meant the court could find a way of treating her as a job applicant. I suspect that if the letter had said, in effect, first things first, we're looking at changing the hours of your work, if he agrees to that, then there might be a subsequent need to change the location. The outcome of this case would be rather different. But the obvious point is, if you act for claimants, this is a powerful argument for encouraging individuals not to opt out of a transfer before it goes through, if they're thinking of bringing a claim. What made it more difficult here, of course, was that Shropshire doctors voluntarily found her a role when she opted out, which enabled her to stay with them. Therefore, she didn't want to transfer across to NHS Direct purely for the purpose of protecting her legal claim. She wanted a job. Anyway, so that's the case of NHS Direct and Gunn. Next, second and last case today, A and the Commissioners for HMRC. This is a case which was reported last week and which got a fair amount of comment at the time, because at first sight the conclusion it reached was startling. However, having been through the case in detail, I think the reasoning is less startling, but it's still an important case. Case was decided by the First Tier Tribunal Tax Chamber. As a result of an application made by the individual, he is anonymised, and his employer's details are as well, so I'm simply going to call them the appellant and the employer. In short, the conclusion of the tribunal was that £600,000 got paid to him at the time of his redundancy, but it was a tax-free sum. So as you can imagine, this got quite a lot of people quite interested in this case. The factual background, as summarised in the decision, is that the appellant started working for the bank in about 2003. Within 12 months, the subject of his bonuses had become very contentious. He complained in 2004 and then again every year after that he was not getting the sort of bonus that his performance merited. He also felt his colleagues were being treated more favourably than he was. The bank in question was bought out in the latter part of 2007, and it was known that redundancies generally were imminent. At that stage, however, he personally was not proposed for redundancy. He wrote to the bank in November 2007, setting out the grievances, and saying that in relation to his bonus, he believed that he was both contractually entitled to the bonuses, as a result of some conversations he'd had with senior management over the years, but also that he'd been subject to unlawful discrimination on the grounds of racial or ethnic origin. He never pursued, he didn't take further the contractual claim, but there was a lot of subsequent correspondence focusing on allegations of race discrimination, which he did not back off one iota. In March 2008, he was told he was being made redundant, and there was then a subsequent compromise agreement, which he signed, which included a statutory redundancy sum, an ex gratia redundancy sum, and the sum of £600,000. Now, the key point to bear in mind about this case is that HMRC accepted that Section 401 of the Income Tax, Earnings and Pensions Act 2003 did not apply. Now, that's the section we all know. That's the usual section which we deal with when dealing with terminations, because it's a blanket provision that applies to, quote, payments or other benefits which are received directly or indirectly in consideration or in consequence of, or otherwise in connection with, the termination of a person's employment, unquote. Instead, here, HMRC tried to argue the payment was taxable under Section 62, i.e., it was income from employment, on the basis that it qualified as earnings, quote-unquote, within the meaning of Section 62. So why did HMRC not argue the payment was chargeable under Section 401, when of course it would have been fully taxable, apart from the first £30,000? Well, the judgment records that HMRC had not made any argument to suggest that Section 401 was engaged, so we don't know precisely. My guess, and it is no more than that, I think this is a key point too, it may well be that HMRC recognised that the dispute and the allegations of discrimination had been circulating long before the individual was notified of his redundancy. It had nothing to do with his departure, that dispute. Therefore, if the payment was made in settlement of that existing dispute, it was not a payment in connection with the termination of his employment. It happened at the same time. That's a different point. Well, if it wasn't a payment in connection with the termination of his employment, as HMRC accepted, was Section 62 engaged? And this relates to earnings from employment. And the argument was that the dispute related to bonuses, which he claimed had been inadequate on the grounds of racial discrimination. The Tax Tribunal decided that the payment was not a reward. The £600,000 payment was not a reward for services past, present or future. It was made on the grounds of the bank's concern about the strength of the discrimination claim against it, and as such, it did not qualify as earnings. And in coming to this conclusion, I should add that the tribunal, the Tax Tribunal, felt able to interpret or read between the lines the bank's response, explaining why it had made the payment. So their conclusion was not even in line with the bank's own reason put forward when asked to comment. As such, the Tax Tribunal found that the payment of £600,000 was in respect to the claim for race discrimination. They said it did not follow that simply because the bonuses, if they had been paid to him in the normal way, would have been taxable, necessarily a sum paid as compensation for discrimination for underpayment of those bonuses was also taxable. The tribunal asked itself what would have happened if the same sum had been awarded by a tribunal if a claim had actually gone through to a full hearing. As the tribunal put it, quote, "When we posed the question, why did the employee receive the payment? The answer is not that it was in return for the employee's services, but because it has been determined that the employer has acted unlawfully by discriminating against the employee." Unquote. The tribunal then went on to say that a payment made in settlement of the claim has the same tax character as the claim which it is in settlement of, which is sensible enough. So what does this mean? Well, first, I think it's going to be a relatively unusual situation where there are existing discrimination claims properly formulated before the individual's employment is terminated. In addition, such discrimination claims have nothing to do with the termination of the individual's employment. There could be a complication, for example, if the individual was claiming to be victimised for having raised earlier allegations, if the victimisation was said to be the decision to terminate his or her employment, then this might be an own goal, because the individual would in effect be saying his or her claims for discrimination during employment, and the sums paid as settlement to end the employment might be connected. Secondly, claimant lawyers may be keen to run an argument that sums paid for discrimination during employment by way of compensation for lost benefits, bonuses, etc. are tax-free. However, this case may yet be appealed, and it would be a brave employer to place reliance on this single case. Thirdly, if an employer is settling a case on the basis that the employee may choose to assert that payment relates to pre-termination discrimination, an employer needs to be aware that the settlement may not be the end of matters. Here, clearly the relevant bank would have been embarrassed by the disclosure in a public court of the allegations of race discrimination. It may be necessary to agree specifically, if the employee is indicating an intention to claim the sum as tax-free, how this is to be handled so that the employer's reputation is not undermined. So, overall, my view is that the case, clearly interesting on the meaning of the term earnings under Section 62, is based on an unusual set of facts and therefore is probably of limited application, even if the case doesn't go on appeal. So, third and final bit was just some thoughts around the proposed changes to employment law by the Conservative government. We've now had the Queen's speech, so we have the initial indications of the follow-up by the Conservative government to their election manifesto pledges. As someone who studied employment law at university back in 1982, I think it's remarkable how the importance of employment law in general elections has changed. In 1982, of course, you had laws being passed which were the foundation for curbing strikes, and which were part of a series of measures designed to weaken trade union power. And as such, both in 1979 and 1983, employment issues were front and centre of the election campaign and what was the right course of action. We've had an echo of that now, but in terms that are much less significant. And whilst these proposals, some of them will still be very controversial, I doubt if anyone voted for or against the Conservative Party purely on the basis of their employment policies. The first proposal is a hangover from the previous Parliament, which is the banning of exclusivity clauses in zero-hours contracts. This is in fact now law because the original proposals were in the Small Business, Enterprise and Employment Act of 2015, and the government's lost no time in introducing and implementing regulation to trigger the ban on exclusivity clauses in zero-hours contracts. I have to say, I do wonder about the extent of the protection offered by this exclusivity ban. I can certainly understand in theory why it's offensive to tie an individual into an employer without, I'm using the term employer loosely, but tie an individual into an employer without the employer being tied to the individual. However, it does seem that it'll be so easy to step around the exclusivity ban, e.g. by offering minimal amounts of work, that I'm not entirely sure about the extent of the protection. Also, I'm really not sure how frequently individuals are actually tied in exclusively and formally to a single employer on a zero-hours contract. And I'm sure there's a fundamental problem with all of this. If the employer is sufficiently strong in market terms to insist on an individual being exclusive to it, without the individual having the right to receive work, then what's to stop the employer simply saying, I'm not going to offer you any work at all if I find out you're working elsewhere? So long as there is no obligation on the employer to actually offer any work at all, it does seem this is a fairly fundamental problem. The second proposal is part of a series of proposals in connection with strikes and industrial action. The Conservative government said Conservative Party said in its manifesto, and has again reiterated now it's in government in the Queen's speech, that it's going to make it harder to take industrial action. First of all, there's going to need to be a minimum turnout of 50% of all eligible voters before even a majority voting in favour of industrial action will legitimise the vote. Secondly, in some of the essential services such as fire, transport, health and education, there's going to be a further requirement that something like 40% of those entitled to vote have got to vote in favour of industrial action, in addition to there being a majority in favour of industrial action. The Queen's speech also contained references to measures designed to stop intimidation of non-striking workers and for time limits to be introduced for how long a ballot can authorise a subsequent strike. Now, my sense of all of this is I wonder about the need for these changes in the law. We have, historically, a low level of strikes in the UK. That hasn't changed. Many employment lawyers can now go their whole professional career without litigating the subject of industrial action. The strike clause, which were introduced during the 1980s and which were highly contentious at the time, have now survived multiple changes of government. And it's noticeable that the Labour Party, when it was in power, did not seek to repeal them, as it would undoubtedly have done if they'd come to power during the 1980s. There is a danger, I think, that by toughening up the laws, there'll be a consensus view created that the strike laws are, in principle, unjust and need to be changed. Now, these proposals will undoubtedly make it tougher for industrial action to be taken. But I'm not certain how many ballots for industrial action go ahead where there is a majority in favour of industrial action, but only a small minority of individuals actually bothered to vote. Unions, in my experience, are fairly cautious about calling out a workforce on strike, unless they think that the workforce actually supports the industrial action. Otherwise, they undermine their own position and do no good for their members. Thirdly, of course, we've got two major constitutional changes. We have the British Bill of Rights, which is for now not proceeding, but is going to be subject to consultation over the next 12 months. Clearly, it's proving a challenge to establish how the Supreme Court in the UK can be the ultimate arbiter for human rights matters in the UK, whilst the UK complies with its international obligations. I've seen articles which assert that the Human Rights Act is enshrined within the Good Friday Agreement and devolution arrangements with Scotland. So, no problems there if that's the case. Anyway, the change isn't going to happen for the foreseeable future, that's for certain. And the other thing, of course, is there's going to be a referendum based on continued membership of the European Union, which is due to happen by the end of 2017. You don't need me to tell you how significant it would be for employers and employees alike, and employment law as a subject, if Britain were to leave the European Union. So I think that's a neat summary, and it segues probably into the ultimate words of wisdom on this subject, which I think were sung by The Clash many years ago. Know your rights, all three of them. Thanks so much indeed for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.